Okay, so good morning, everybody. Thanks for joining us today and welcome to our webinar on commercial agency law. My name is Suzanne Carr. I'm one of the partners in the dispute resolution team at Myerson, and I'm joined today by my colleague Robert Brothers, who is a senior associate in the team. We're both specialists in commercial agency law. We undertake work for both agents and principals on a day-to-day basis. And we're looking forward to sharing some of our knowledge and experience with you this morning. As usual, the webinar will be recorded today, and we will circulate it afterwards to everybody who's attended. And it will also be posted on our YouTube channel, so there's plenty of opportunity to revisit the webinar later on if you want to do so. At the end of the session, we'll have our usual question and answers. So please feel free and do post any questions on the Q&A function at the bottom of this screen, and we'll attempt to answer as many of those questions as possible at the end. I anticipate the presentation today will last for around 30 minutes. So just to run through what we're going to cover today. First of all, we'll have a brief recap on the regulations, followed by a quick summary of an agent's entitlements under the term upon termination. Then the thrust of today's webinar, which is a practical guide for valuing an agency claim. And then at the end, I'll just touch upon jurisdiction and governing law, and then an update following Brexit. I imagine that most of you attending today, you will be aware of the basic rights under the regulations. They've been around as a piece of English legislation since 1993, and they enacted the EU directive on commercial agency law. So I don't intend today to go into any depth on the entitlements as such that arise from the regulations, but what I want to do is focus on the entitlements which arise specifically upon termination of an agency contract. But I think it will just be helpful just to run through a couple of the main points. So the legislation, it's a relatively short piece of legislation. It does leave many questions unanswered, and there isn't a huge amount of case law in this area, and that by of its nature means that it gives rise to disputes between parties on questions which there just is no black and white answer, or the issue just hasn't been determined by the courts either way. The regulations are mandatory, so they can't be excluded in their entirety by the parties under an agency agreement. There are, however, some elements that can be excluded, and that's clear because the regulations say so. It will expressly say if a regulation can be excluded. There are other aspects of the regulations where the regulations say it can't be excluded, and then there's other regulations where the regulations are simply silent. So those are the areas where parties are left wondering, can they be excluded or not? And that is generally where the disputes will arise. Not all sales agents will be afforded the protection of the regulations. And so the first question is, do I fall within the regulations? Where we start is we look at the definition of a commercial agent, which is set out in the regulations. And the key things we're looking for are, is the agent independent of the principal? Are they authorised to sell the goods on the principal's behalf and not in their own name? And is the agent remunerated for doing so? And the remuneration can take any form. It's usually by way of commissions, sometimes by way of only a retainer, or sometimes a mixture of both. What is clear is that if an agent is simply selling services, then they won't be afforded the protection of the regulations. There are many agents where they will have a mixture of selling services and goods, and in those situations the position is more nuanced, and that does require a more in-depth consideration of exactly what the agent is doing to determine whether or not the regulations are going to apply. So the regulations are a piece of legislation which is designed to protect agents, and it offers extensive rights to the agent both during the agency and upon termination. Throughout the agency, there is the right to information and documents to enable the agent to properly perform the agency role. There's the right to have a written contract upon request. And then, as I say, there's various entitlements following termination of the agency, and that's what we propose to focus on today. Principals do also have protection under the regulations, but to a more limited extent. An agent will owe a principal, its principal a duty of good faith and is under a duty to cooperate. And what that means for the agent is that the agent must comply with the principal's reasonable instructions throughout the course of the agency. So moving on to the entitlements of the agent following termination. So I think it's fair to say that the majority of the work that we do involves termination scenarios where an agent has either had the agency terminated by the principal or has been told by the principal that the agency is going to be terminated in the near future. Or sometimes the agent has actually terminated the contract themselves, or the agent is considering terminating the contract and wants to understand what their entitlement would be in that scenario. So the questions are usually, what am I entitled to? How do I value those entitlements? How do I go about pursuing my principal to get what I'm due? And is it worth my while pursuing a claim? What are going to be the likely costs? And whether it's proportionate to pursue the claim will usually depend somewhat on the value of those entitlements. So when an agency contract is terminated, there are going to be various payments to which the principal has to make to the agent. There are 4 key entitlements, and those are pre-termination commission, post-termination commission, which we generally refer to as pipeline commission, a minimum notice period, and then compensation or indemnity. And Rob will talk shortly about how we approach valuing each of those separate entitlements. But before we move on to that valuation section, I just want to run through the basis of each of those entitlements under the regulations. So firstly, we have the entitlement to be paid commission on orders which are concluded before the termination of the agency. And that will include orders which have already been invoiced by the agent but are awaiting payment by the customer. This entitlement arises under Regulation 7, and the entitlement will arise only where the order is concluded because of the agent's efforts. And that has to be with a customer or within an area which is exclusive to the agent. So Regulation 7 is pretty simple, no real issues there. Then we have Regulation 8, and this is all about the entitlement to post-termination commissions. And it's an entitlement to post-termination commissions for what's described in the regulations as a reasonable period. And that definition of reasonable period isn't defined in the regulations. It's only an entitlement to commission on transactions which are concluded because of the agent's efforts. So it's not necessarily all transactions, and Rob will come on to that shortly. This entitlement, I think it's fair to say, it's more difficult to discern than Regulation 7 commission. There are a couple of things to note about agency contracts and Regulation 8, and they are these. We do sometimes see the attempt to exclude Regulation 8 commission within an agency agreement, and the question is that sort of clause enforceable? These types of clauses, sometimes they're very obvious and it'll be absolutely clear that the clause is attempting to exclude Regulation 8 just by the very nature of its wording. Other times it's less clear, but the intention to seek to exclude Regulation 8 can be discerned from the contract. The problem with Regulation 8 is that the issue of whether or not it can be excluded hasn't been determined by the court either way. And there are arguments which can be run by both agent and principal, which support opposing views. So it's often an area where the disputes arise in agency claims. And the question is the exclusion enforceable or not? But the good news from an agent's perspective is that although this is quite a rife area for dispute, in our experience, more often than not, it does result in a compromise between the parties within the terms of a settlement, as both parties, if properly advised, will generally recognise the risks. The second point to note about Regulation 8 is that sometimes, but probably less commonly, the parties will seek to agree this entitlement in advance in the agency agreement. Typically, a clause will do so by specifying what the reasonable period is. So it may, for example, say that the reasonable period is 6 months. And generally, we find this to be fairly helpful because it provides the parties with some certainty and it narrows the areas of dispute. And provided the clause is reasonable and it's not detrimental to the agent, then we would generally, recommend that the parties seek to agree that clause and to avoid that element of dispute. Moving on to Regulation 15. This is the regulation which provides an agent with an entitlement to a minimum notice period. That notice period is up to 3 months, and whether it's 1, 2 or 3 months will depend on how long the agency has existed. It's perfectly fine for the agent and the principal to agree to extend this period, but it cannot be shorter than the minimum period provided by the regulations. If the principal does not provide any notice or it gives less than the minimum notice, then that's going to give rise to a damages claim on behalf of the agent for commissions over the period for which the notice hasn't been given, and Rob will talk a little more about that shortly. So Regulation 17, this is the key area we wanted to talk about today. It's usually the most valuable entitlement for most agents. It gives the agent an entitlement to a termination payment, and that's on one of two bases. It's either compensation or indemnity. Now, both of these fall within Regulation 17, but they are very different entitlements in practice. They seek to compensate or provide a termination payment on two very different bases. So first of all, we have to determine which one of these applies to the agent in question, and the answer is generally very simple. If the agency agreement does not say which one applies, then the agent is going to be entitled to compensation, as that's the default option. So it's only where the agency agreement specifies an indemnity that the indemnity alternative is going to be the relevant one. So we'll start by looking at the agency agreement to see which of those two options is applicable. The second question we often get from agents is, well, which is going to be more favourable for me? Is it going to be compensation or indemnity? And there's no straight answer to that. Typically, claims for compensation tend to result in a higher payment to the agent, but every case is very different, and there are most certainly instances where an indemnity will produce a higher valuation for an agent than the compensation alternative. And generally that tends to be for low earning agencies. But as I say, there is no one rule fits all here. Sometimes an agency contract will attempt to exclude the termination payment. It might refer to Regulation 17, it might not, it might just be very broad in terms of seeking to exclude any liability of the principal to the agent upon termination. That type of clause won't be enforceable. The regulations specifically prevent that from happening. There are simply some aspects of the regulations which I mentioned earlier, which the regulations expressly prevent derogation from. So if there is such a clause in your contract, do seek advice, because it's likely, as I say, to be unenforceable. In the same way as Regulation 8, we sometimes see clauses which might seek to determine the Regulation 17 entitlement in advance. Now, sometimes that will be enforceable, sometimes it won't. What we would have to do is we would have to compare the agreed entitlement in the contract with the entitlement under Regulation 17. If the entitlement under the contract is less favourable to the agent than the entitlement would be under Regulation 17, then that contractual clause is going to be unenforceable. However, if the contractual clause offers, a greater payment to the agent, then in principle there wouldn't be no reason why such a clause wouldn't be enforceable. So it's important to note that there are circumstances in which the right to compensation or indemnity would be lost. And it is an automatic right upon termination, but if an agent finds itself in one of the scenarios that I'm going to describe in a moment, then the entitlement to that Regulation 17 compensation or indemnity would simply be lost completely. So when is that entitlement going to be lost? Well, it would be lost where the agent terminates the agency himself, or where the agency is terminated by the principal because the agent was in serious breach. Now, there are some exceptions to this. So, for example, an agent might terminate the agency himself because he's retiring on the grounds of ill health or has reached a reasonable retirement age. And in that situation, the entitlement to Regulation 17 payment would remain. Another situation is where an agent terminates the agency because the principal is in very serious breach of the agency agreement. And again, in that situation, if the agent can show that they had the grounds to terminate on that basis, then they will remain entitled to the compensation or indemnity. So every situation is going to be very different and will need to be analysed on its facts. What I do want to say is that if any agents are at the point where they're considering terminating their agency, either because of the principal's conduct, or even if they are considering retiring, or they're suffering ill health forcing them to have to end the agency, do please seek advice, because once that notice of termination has been served, then you can't just simply retract it unless, of course, the principal agrees. And if the agent gets this wrong, for example, they terminate thinking that the principal is in serious breach, and it's found that that breach wasn't so serious as to justify that immediate termination, then the agent's going to find themselves in a situation where they've forfeited that significant entitlement under the regulations. I mentioned retirement. Retirement is outside of the scope of today's webinar. I've said that where an agent retires, they will generally retain the right to compensation or indemnity. There is a warning here. If an agent is operating through a limited company, then more careful consideration needs to be given to that, because technically a company can't retire. So please do seek legal advice if you're in that situation. And finally, if an agency is terminated, the agent has 1 year within which to notify the principal of the intention to claim under the regulations. Otherwise, the entitlement will be lost. So I hope it's apparent from that brief. I appreciate it's a very brief canter through the entitlements upon termination, but what is important is not for an agent to necessarily understand all the technical detail of these entitlements, but just to have a general awareness of the scenarios of when the entitlements will arise, what those entitlements are, and most importantly, when those entitlements might be lost. That will enable the agent to know when they need to seek advice to make sure that their position isn't prejudiced and they don't lose any of those really significant entitlements that the regulations afford them. So that brings me to the end of my section on entitlements, and that leads me to hand over nicely to Rob to give you a practical guide on valuing the agency claims. Thank you.
Thanks very much, Suzanne. Good morning, everyone. I think it's safe to say by now most agents are aware that when their agency terminates, they're usually going to be entitled to claim compensation and pipeline commission, etc., under the regulations. In practice, most disputes that we see come down to valuing these entitlements and negotiating a final payout figure from the principal. So since there are different entitlements to consider, it can sometimes be difficult to know where to start. I find the best approach is to consider each entitlement as its own separate component. And perhaps even the agent could prepare a summary table of the entitlements to help keep track of the calculations. The logical position to start with is Regulation 7 compensation. That's the commissions owed to the agent up to the date of termination of the agency, which Suzanne has just gone through. That's usually really straightforward to calculate. The agent will simply be due commission in the usual way in accordance with the agency agreement up to the date of termination. So when the agency is terminated, the principal should ideally provide an agent with a final account or a commission statement which sets out the orders that have been received up to the date of termination, and then pay the agent what they're owed. We would expect that the agent and principal should be able to agree between themselves a figure for Regulation 7 commission, because by the date of termination, they should know what sales have been concluded and run the calculation. However, it's important to note that if a principal doesn't pay an agent the compensation they're due in the usual way, the agent would of course be entitled to make a claim pursuant to Regulation 7. But what if there are orders that conclude after termination? They would of course fall outside of Regulation 7. As Suzanne has highlighted, an agent is entitled to commission on orders concluded after termination, provided those orders are received within a reasonable period, and where they're mainly attributable to the agent's efforts, and this is more commonly known as pipeline commission. In calculating that, we have to look at the orders that conclude in the agent's territory in the months after termination. And this is information that the principal will have to disclose to the agent when it becomes available. The next step is to identify which of the orders are mainly attributable to the agent's efforts when they were performing the agency. In other words, we would look at whether the agent was the effective cause of the transaction. And that is generally very fact specific. The last step is to determine the reasonable period, which is usually expressed as a number of months after termination. So I think a clear example of when an agent would be able to bring a claim for pipeline commission would be if shortly before the agency is terminated, the agent secured orders from a new customer who then continued to place orders for the same product, say, for the next 6 months after termination. In these circumstances, there's a clear link between the agent's efforts and the conclusion of those transactions. And the agent should be able to claim pipeline commission on those orders for the next 6 months. Another example, which is a little less clear, is where there's an established customer which the agent introduced in the early days of the agency. But by the time of termination, the customer is simply reordering products without any actual effort being made by the agent to secure those orders. In these circumstances, it might be argued that the agent wasn't the effective cause of the orders from that customer that come in after termination. So that's just something to be aware of. So in summary, the calculation of pipeline commission requires an analysis of orders which the principal receives after termination, However, the most common scenario Suzanne and I encounter is that information on post-termination orders just simply isn't available yet because the agency has just been terminated. In that scenario, what we normally do is look at the previous year's commissions, say commissions over the last 3 years. And that allows us to calculate a monthly average, which we'd then multiply by a reasonable period, which in our experience tends to be in the region of 6 to 12 months. It's a fairly broad brush approach, but it should give a good indication of the orders that are likely to come in after termination. And it's a really good starting point for negotiations with the principal. Of course, if there is further sales information disclosed later on, then that calculation can be adjusted. I'll now move on to statutory notice under Regulation 15. So agents are, of course, entitled to receive minimum notice periods, and the length of that notice depends on the duration of the agency. So an agent is entitled to a notice of 1 month for the first year, 2 months for the second, and 3 months for the third, and thereafter. It might be best illustrated by way of an example. So say we've got Stephen Smith, who has been an agent for the last 5 years, and he's been given notice of termination on the 1st of July, 2023. Since Stephen has already done the 3rd year of his agency, he's entitled to receive 3 months notice ending on the 31st of October, 2023, because it has to, the notice always has to end at the notice always has to expire at the end of a calendar month. So if Stephen hasn't been given his full lawful period of notice, that would entitle him to bring damages for loss, and that would be his net loss of earnings for the relevant period, or in other words, his commissions that he would have earned had he been allowed to work his notice. The best indicator of what commissions he would have earned would be to look at the previous months and probably work on an average. It's important to note here that Stephen's only able to claim his net losses, and therefore anticipated earnings during the notice period must be calculated net of expenses, whatever they are. So finally, turning to indemnity and compensation under Regulation 17, as Suzanne noted, these are usually the entitlements which attract the highest value in an agency claim. They're calculated very differently. Generally speaking, compensation is more favorable to the agent because the level of compensation is unlimited, where the indemnity award is capped. I'll deal with indemnity first. The calculation is relatively straightforward, and I think it's best broken down into 3 stages. So stage 1 is where you calculate your sort of baseline indemnity figure. You firstly identify the customers that the agent introduced to the business, and existing customers which the agent significantly increased the volume of business. Once you've got those 2 lists of customers, you identify the turnover produced by each of them during the 12 months before termination. You then identify the gross level of commissions earned by the agent based on the turnover of those customers. You then factor in how long the business of those customers will last. So that's normally we'd say 2 to 3 years is a general guide, although for negotiation purposes, an agent might argue a higher period and the principal will invariably argue a lower period, and it'll be very fact specific. You then make a deduction to reflect the likely level of migration of existing customers, which is trying to reflect the fact that even steady customers might cancel their business with the principal and move elsewhere. So we'd say up to 25% per year migration rate is a general guide. However, customer loyalty needs to be carefully considered. And the last part of that calculation is you make a deduction to reflect the level of expenses the agent would have incurred had he continued working for the principal. And then you should have your baseline indemnity figure. Stage 2 involves looking at equitable considerations. In other words, what's fair in all the circumstances when determining the final indemnity award. Multiple factors can be taken into account here. I'll give you an example. For example, a restraint of trade clause can increase the indemnity, whereas an agent's breach of the agency agreement or an agent's poor conduct can be used as a justification by the principal to reduce it. So once you've got your final indemnity figure and you've considered equitable considerations, you apply the statutory cap, which is the average of the last 5 years' commission, or less if the agency is less than 5 years old. The statutory cap is the maximum indemnity that an agent can claim. And if after stage 1 and 2, the indemnity is lower than the cap, then the lower sum is payable. And if it exceeds the cap, then the cap is payable. And one final thing to note on indemnity is that when it comes to indemnity, we normally see that agents typically think that the statutory cap is their indemnity entitlement without considering stage 1 and 2 of the calculation. That isn't correct. And I think agents should be prepared that their principal will insist on the full indemnity calculation being followed, since after stage 1 and 2 of the calculation, the indemnity could be significantly lower than the cap. So that's just something to bear in mind, and I think highlights the importance of agents seeking specialist legal advice when it comes to calculating this entitlement. Turning to compensation, as I said, this is calculated very differently to indemnity. And again, please remember it's not capped like indemnity. Compensation should reflect the value of the agency business at the date of termination, and its purpose is to compensate the agent for the loss of the agency. The valuation exercise involves an analysis of the agent's projected future income stream and assessing what a hypothetical purchaser would pay for that. So the usual approach that we use when calculating compensation is to take the net annual earnings and apply a multiplier. So in other words, that's done on a capitalized earnings basis. So I'll run through the basic formula for calculating compensation. The first step is that you assess the annual income of the agency, and you generally look at the previous year's earnings to calculate this. When you're looking at the previous years, you might look at factors that have affected income over the years, because it might have gone up and down depending upon various reasons. For example, many agencies were affected negatively by COVID-19. So you might query whether income generated during COVID-19 should be excluded for the purposes of calculating the projected future income stream of the agency. Once you've got your annual income figure, you deduct the likely costs of running the agency, which will include both fixed and variable overhead costs and other expenses connected with running the agency day to day. If the agent has multiple agencies, then query whether the expenses can be apportioned between those agencies. Then you deduct the cost for someone to run the agency, which would be borne by a hypothetical purchaser. This is known as a notional salary or notional labor cost. In determining that, you might look at salaries for comparable roles, and you want to look at the actual time spent running the agency day to day, which should be factored in to the notional labor cost. So by way of example, if the agent only worked part-time, then the notional salary should reflect that, where if the agent worked full-time, then that would attract a higher salary and then a higher deduction from the annual earnings figure. So once you've got your net income figure and you've you've deducted your costs and you've deducted your salary. You then apply a multiplier, and the multiplier should reflect the hypothetical purchaser's perception of risks associated with the agency. The main risk being that the projected income stream won't continue. So for the purposes of the compensation calculation, it's always assumed that the hypothetical purchaser will want to make a profit on its investment. And therefore, if there are risks which affect that investment, then that should be reflected in the multiplier. So some of the factors affecting the multiplier can include the future performance of the agency and whether the agency is likely to grow, the profitability and sustainability of the principal's business, security and supply of goods, the size of the agency, whether there's an over-reliance on one customer in respect of the agency's income, and a risk that customer may go elsewhere and thus affecting the commission income. So just in summary, valuations of compensation it's a nuanced and complex exercise, and it typically requires input from a forensic accountant. This is especially the case if an agency claim ever goes to court. And we'd always recommend agents take specialist legal advice when calculating compensation and their other entitlements. So that brings me to the end of my section. I hope you found it useful. I'm now going to hand you back to Suzanne, who's going to briefly discuss jurisdiction and governing law and a Brexit update. And then there'll be an opportunity at the end for us to answer some of your questions. Thanks very much.
Thanks, Rob. Okay, so I'm conscious that we're just over half an hour, so I'm going to have a quick run through the last couple of sections. So I just wanted to touch upon jurisdiction and governing law, which is something which needs to be considered following the termination of any agency where an agent is looking to pursue a claim against the principal. So the two questions are, which law is going to apply to determine the dispute, and where would the claim need to be brought, i.e. in which courts? That's known as jurisdiction. The regulations only apply to agents conducting their activities in Great Britain. So in situations where there's no agency contract, but the agent's performing agencies in Great Britain, then the regulations will apply, and the English, the English law will apply to determine the dispute. And the claim would be brought in the English courts. If there is an agency agreement, then we would look at the agency agreement to see, have the parties agreed between themselves which law is going to apply? Because it is possible that although the agent might be conducting their activities here in Great Britain, that the parties could have agreed that a different law applies. And this generally happens where the principal is in a different jurisdiction. So for example, a French principal may well have its own standard agency agreement that it uses for all sales agents, and will generally tend to say that French law would apply. So in that situation, French law would apply to govern the dispute. And we then need to have a look at whether the parties have agreed where the claim is going to be brought. If the position is such that it is going to be the law of a different jurisdiction which applies, then we would be able to put you in touch with a specialist in a different jurisdiction to assist. If the parties agree that a different law applies, generally that's not going to be an issue. Although every other EU member state has implemented the directive in its own way, the local law of that country will still afford agents significant protections. So all is not lost, even if it's not English law that's going to apply. And then finally, the best news of all is that for the foreseeable, the regulations continue to be effective in English law. Some of you may be aware that very recently the government announced an intention to scrap all EU-derived legislation by the end of this year, and that would have encompassed the regulations. However, there has now been a change, and the government is now focusing on a targeted list of 600 pieces of legislation, which I'm pleased to say doesn't include the commercial agency regulations. So for the time being, the regulations do remain in force as a piece of what's called retained EU law, which gives agents and principals some certainty going forward as to their rights. However, it's fair to say that there could be developments in this area, so we will keep an eye on any developments, and if there is anything which arises, we would publish something on our website in that regard. So that brings us to the end of today's webinar. I hope you found that really helpful, particularly Rob's section on valuation, which I think is an area which agents and principals will find really beneficial in terms of the approach that needs to be taken when an agency is brought to an end and those claims have to be valued. So that brings us on to our question and answer session. We do have one question here, so if you can just bear with us a moment, we'll just have a look at the questions and then answer those as best we can. So we've a question which is, if an agency contract includes a guarantee of a lengthy pipeline commission, for example, over several years, would that reduce the value of the claim for compensation? The answer to that is probably not, because they are two separate entitlements. If the parties have chosen to provide the agent with a guarantee of, for example, 2 years pipeline commissions, the agent is still entitled to be compensated or indemnified under Regulation 17, and those are two different entitlements. There is sometimes debate as to whether there is a sort of an element of duplication here between the regulations, and it's possible that a principal may argue that the value of compensation should be reduced, but I think there's a very strong argument to say that it shouldn't. Rob, do you want to answer the next question?
Yeah, sure. I've got a question from John. If a principal is in breach of contract without terminating the agency themselves, as a consequence, the agent wants to terminate, okay, would compensation or indemnity apply? So yeah, so if the principal is in very serious breach of contract, which is fundamental to the performance of the agency, the agent does have the right to terminate the agency agreement. Although a word of caution on that, I would always seek legal advice before you take that step. But in answer to your question, would compensation or indemnity apply? Well, it depends. If the agency agreement is in writing and it provides for an indemnity, then an indemnity would apply. If there is no agency agreement, or the agency agreement is silent as to an indemnity entitlement, then compensation is the default position. So I hope that answers the question.
Thanks, Rob. There's another question. Is there a typical multiplier that applies to a long, well-established agency with, say, a direct commission income of £100,000 as an example? Typically, as Rob mentioned, compensation is usually valued on a capitalised earnings basis, although there are other bases of valuation which we haven't touched upon today. They're much less common. With the capitalised earnings basis, the multiplier, where it's a post-tax multiplier, and I say that because there are pre-tax multipliers which can be used as well, but that's getting into a little too much detail. So taking a post-tax multiplier, that is typically between 1 and 5. but they're if it's a long, well-established agency, the fact that it's a well-established agency doesn't necessarily mean that the multiplier would be at the top end. There could be other factors, other risk factors, which could mean that the multiplier is lower than the top end. So it's very much a case of analysing the particular agency and all of the risk factors. But certainly, if it's well established, that's going to assist with the multiplier being at the sort of higher end. Rob, do you want to take the next one?
Yeah, I've got a question from Alan. New limited company has taken over the company that I worked for 40 years. Does that mean my years of service are lost? I think the simple answer to that is no. If you've been working for your previous principal for the last 40 years and the principal has then since been acquired by a new company, your agency agreement, well, depending upon the terms of sale, should continue, and your years of service wouldn't be lost. But I'm not quite sure that would really affect any calculation of compensation or indemnity if your agency was then terminated. But it's a good question, and you know, something that we often encounter where an agent's agency is affected by the acquirement of their principal, and it can lead to changes in culture and changes as to how the new principal approaches commercial agents. So Suzanne,
Thanks, Rob.
we've got another couple there.
Yes. A brand wants to open a showroom in London and offer me some exclusive customers of my choice, but I'll then be competing with the showroom for orders. They've not mentioned termination, but I feel over time I'll be cast aside. Can I terminate and be compensated? Possibly yes. This is all about variation of the agency terms. If the principal here is seeking to impose a significant change to the terms of the agency, which from what you said, it sounds like it may well be, then it can't do so without your agreement. So if they try to impose that change, that would give rise to a right to terminate the agency and be compensated. But this is a situation where we would recommend that you get advice, because as I said in the webinar earlier, if you terminate and get that wrong, you would lose that right to be compensated. So the question there is about whether the principal is in repudiatory breach, entitling you to terminate.
Okay, we've got a question here from Heather. It's clear that agency law is a specific niche area requiring specialist lawyers. If a claim is brought to court, is the sitting judge who decides the outcome of the case also likely to have a detailed knowledge of agency law? Well, I mean, when we issue agency claims, we typically issue in the High Court business and property list, and normally in Manchester, and there are specialist judges that sit in Manchester that can hear agency claims. In our experience, most claims that we see don't actually, whilst they might be issued and get to the earlier stages of the court process, we normally don't see a fully contested trial, because very often agency claims settle, you know, by way of mediation, or through correspondence and offers exchanged, etc. But in answer to your question, a judge sitting at a contested trial will have some knowledge of agency law, and the barristers that are presenting the case will be specialists in agency law, as will the people presenting the case as well, and that'll assist the judge in making a determination on the facts of the case.
Thanks, Rob. We have a question here about the death of an agent. I think the question is about if upon the agent's death, will the I think the question is, will the agent's estate be entitled to claim? And the answer is yes. So the rights of the agent will pass to the agent's estate. So the personal representatives of the estate would be permitted to pursue that claim on behalf of the estate against the principal. I think that's a simple answer to that one. So there's one other question, which is about sort of along a similar lines. It's about retirement. The question is, do I have to retire from all my principals, or can I keep working for one? There is nothing to stop you from continuing to work for other principals, but this is a situation that Rob and I have encountered quite recently, in fact. And if you do continue working for other principals, there is going to be an argument raised by the principal against whom you're claiming that actually you've not actually retired, and that's it's a situation where the position isn't abundantly clear. So again, I don't think we have time today to go into that in any more detail, but if you want to have a chat with us about that, then we can do so after the webinar. I'm more than happy to do so. I think there might be a couple of other questions on there, but I think we've reached the point where we're probably going to have to draw things to a close today. We will drop those if we haven't answered any questions on there. I do apologise, and we will drop those individuals a line to pick those up separately after today's webinar. Can I thank you all for those questions? They're all really good questions. I hope we've answered them as best we can, and thank you again for attending today. Thank you.